experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good evening. Welcome to Ask the Experts. We're with you every Monday and Thursday from 6 to 7. Tonight is the first Thursday of the month, which means, I got to say it, I have to say it this way, our number one show. They get more calls, and we've already got people waiting already. They get more calls than any other show, not only that we do, but other shows I listen to. It's just amazing how many calls come in. This is our community association show. We have the top HOA condo association law firm, K. Bender Rimbaum. They have been with us, I think it's been 4 years now, and we get such great letters. People love the show, and it's the easiest show I do. It goes by so fast. Let me welcome you, one of the senior partners, Robert Kay. Hi, Robert.
Hello, Steve. How you doing?
I'm good. I should say board certified attorney Robert Kay.
Board certified, that is correct.
There's a big difference.
Well, it takes the Florida Bar to certify you to be an expert in the field, and there are about maybe 130 in the state at the moment, maybe a couple more, 130 more or less. We have probably 8 of them.
Well, you know what? I want to do something. We normally don't do this, but she has been waiting for so long. Before we go into talking about the firm, I want to go to Donna, who's been waiting for a long time. Let's go to Donna with the first call of the evening. Hello, Donna.
Hello.
Do you have a question for Robert?
Yes, please. We're an association, and our revenues are between $300,000 and $500,000 annually. Do we have to have an independent review as well each year? We have a management company that does the regular, financials, but is that necessary? Is that required?
You say you're between 300 and 500,000?
Yes.
And of that,
I'm looking at the statute in the book, and it says shall prepare reviewed financial statements. Do we have to do that with an independent person, like HR Block or?
your documents say review?
No, I'm looking at the statutes. Not our documents don't really say anything. I'm looking at the 718.
Well, if you're an HOA, you're not subject to 718, you're subject to 720.
No, we're a condo association.
Oh, I'm sorry, I thought you said you were a homeowner association.
No, we're a condo association.
Okay, well, as a condominium association, you are required to follow the numbers that the statute provides for having to do that. And you see the statute right in front of you, yes?
Right, but what I'm confused about, it doesn't say if it has to be done yearly.
It is an annual
necessary to
financial
do.
requirement. If your documents don't specify exactly what you need, you are allowed to present it to the owners on an annual basis to do something less. Have you ever done that?
No, we haven't, no. We've been paying to have it done, but I was wondering, is it really necessary? Because it costs like $2,000. And I was wondering, do we really have to do this every year?
Well, you do unless you put it before the owners to allow you to do something less. And if you do that, you can't do that every year. You can do it 2 years and then off a year.
We can do it, what did you say, 3 years and then off a year?
2 years and then off a year.
2 years and then off. Okay.
So you will have to do it at least once.
Okay, all right, but at least it would save us if we didn't have to do it every year, that money.
But you do have to present it to the owners every year in order to do something less. And the
Okay,
statute
you have to
requires you to
present
do
that
that
to
before the
the
year
vote?
begins. Typically, it's done with the annual meeting, but yes, you would need a majority of the owners present at a meeting and voting.
Okay, well, I appreciate your help. I think I understand a little better now. Thank you very much.
Thank you,
Okay.
Donna.
Thank you for listening.
All right, thanks. Bye-bye.
We've got a board full of callers right now, but Robert, tell everybody about your firm, because you know what I've noticed. We had several people write us that their developers are getting ready to turn over everything over to the board. So it's a first-time board, and a lot of people don't know all that's involved. But tell everybody what your firm does.
Well, our firm focuses in the area of community association representation, handling all aspects of the legal needs of a community association on a day-to-day basis, be it involving reviewing your covenants, providing analysis of rights and obligations of the association, the individual owners, additionally dealing with covenant enforcement matters, collection of unpaid assessments, negotiating with contractors, third-party providers of services, dealing with construction defect issues, pretty much across the board, things that associations deal with on an everyday basis. Turnover from a developer is certainly one of the things that is important, that they have good legal representation. Once the turnover occurs, there's timeframes that come into play when developers are supposed to do certain things, when claims can be made, and it's important that those are followed strictly. And that's an important time to have competent, qualified legal counsel.
And so that you know, K. Bender Rimbaum has well over 1,000 properties that they work with, and that's something. Let's go to our next caller, Gabby from Miami. Hi, Gabby.
Hello, how are you?
Good. You have a question for Robert?
Yes, I do. Hello, Robert. My question is very
Hello,
simple.
Gabby.
I just found out that when there is a military applying to be as a tenant, a lease application, there is a law that is 7 days maximum to process those applications. However, when an applicant does not disclose or identify themselves as being in the military service, how are we, association or management company, could be aware of that if they don't disclose it? And if the application surpasses the 7 days, can we turn down an application that does not fulfill the minimum requirements regarding a credit score, which is in the application process, or any other item on the application, and they come back saying, I'm a military, you cannot deny my application?
Well, if they didn't disclose it, obviously there's no way you would know. And if they
Correct.
don't qualify under your documents, then they don't qualify. And I don't believe that them being military or not makes a difference as far as qualification goes. In our experience, that's never been an issue that has resulted in the association being forced to allow somebody to lease or purchase property within the community, particularly when that's not disclosed at the beginning.
Okay, so in any event, if we turn down that application because they do not meet the credit score minimum that we have on the application, now that they're presenting their military ID, they cannot ask us that we do have to approve it because now the 7-day starts according to them.
Well, you've already disapproved it, so the fact that they're telling you they're somehow affiliated with the military after the fact doesn't change the fact that they've already been disapproved.
Okay, I understand. Perfect. Thank you so much.
Thanks,
Okay,
Gabby.
thanks for listening.
Let's go to Mark. Hi, Mark.
Hi, is this Robert?
This is Robert.
Hi, Robert. I love your show.
Hello, Mark.
Listen to it a lot.
Your cousin,
I have
Robert.
I have a specific question. During COVID, we have someone that runs a boutique out of their unit in our community, and it's forbidden to have a business in our community. We put them on notice. They canceled a sale that they were going to have last week. And today, when I was out of town, they had 89 people from out of the community come in. With COVID invited, 89 people that live in the community and outside the community were invited to come to her house or her condominium inside of a building of 26 other units. Is there anything that we're going to fine them for having this when it wasn't supposed to happen? But is there anything that we can do legally about this? Because she's going to do this again and again and again.
Now, what type of business is it?
She has a boutique business. She sells ladies' clothes, pocketbooks, jewelry, accessories, that type of
Oh, okay. And these 89 people, I assume they weren't all there at the same time, correct?
No, they weren't there at the same time, but she was on Facebook inviting people from 11 o'clock to 6 o'clock today.
And do you have any specific restrictions in place for outside visitors under the COVID restrictions?
No, we don't. Not that I know of in our separate community, in our master community. There are 8 different communities within our master community. We don't have any in our separate community, but I don't know if they have any restrictions on COVID. You have to be an invited guest to come in. You have to go through the gate and so forth. But I don't know if we have any restrictions on COVID for people coming in if you're on the guest list.
Well, if there's no restriction that's being violated, then the fact that she's doing something that might not be the smartest under the current circumstances wouldn't be a basis for you to take legal action. You'll need to have some form of limitation on the visitation within the community in order for you to proceed with any kind of formal legal action.
Well, we have a fining committee. We told her to cease and desist, and she canceled the one party, but she had this party today.
I understand, but in order to fine, you have to have a violation of something in your documents, not just because you think what somebody's doing is wrong.
Well, no, we have in our documents that you cannot run a business out of your home.
But has that been allowed for her or others?
I didn't understand. Is that allowed for others? No. You cannot run a business out of your home.
And I thought from what you said initially that the board has been allowing her to do that because of COVID.
No. I said because of COVID, what are the restrictions on her inviting 89 people to her unit throughout the day today from the community and from outside the community? No, the board sent a cease and desist order on her last party, and she didn't have a last party, but she had this one today, knowing that I was out of town.
Well, if I'm understanding correctly, that if she's operating a business out of the unit and that's prohibited by the documents, then you can certainly pursue legal action to get an injunction to keep her from doing that in the future.
Okay. So you have to have an injunction. Okay, that's fine.
Being that you're in a condominium, you probably have to start with arbitration with the Division of Condominium.
Okay, I'll talk to our legal counsel and try to get that resolution done and draw up some covenants or whatever we have to do.
Well, the first thing to do, if you have legal counsel, is for that attorney to make a demand on the person to stop the violation, and that might resolve it without having to go further.
Right. Okay. Well, I did make a call to our legal counsel today, but I just wanted to have this over the air, and if anybody else is having a problem, they know what to do.
Okay.
Very good. All right.
Thanks,
Good
Mark.
luck with it, Mark.
Okay, thank you. Have a great day.
Thank you. We have a line open, 888-565-1470. If you live in a condo association or, I'm telling you, this is the time that you should call in, 888-565-1470. We have one of the finest community association law firms, K. Bender Rimbaum. Robert, give everybody the phone number if they'd like to, because we're going to be talking when we come back about your classes. If you'd like to give out your phone number, people can call tomorrow and make reservations.
Our phone number is 800-974-0680. You can go to our website at kbrlegal.com, click on the calendar, and all the upcoming events will be identified, and then you can click on those to make a reservation.
Okay, we're going to go to break. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back. This is the Ask the Expert show on every Monday and Thursday from 6 to 7 with some of South Florida's finest lawyers, doctors, financial, home improvement. Today it's the first Thursday of the month, so we have K. Bender Rimbaum, and we have board-certified attorney Robert Kay, one of the senior partners. If you have a question for Robert, give us a call now. We have one line open at 888-565-1470. 888-565-1470. So you are your firm is amazing because you give a lot of time teaching, and you have classes that you do all through the month. So let's talk about what's going on in March.
Okay, well, March is already underway. We've already had some. We talked about those last month in anticipation before, but we do have some interesting things coming up. Next Thursday, as a matter of fact, we have a version of Ask the Attorneys, one of your favorite.
I love that.
But it's going to be on Zoom, so it's not quite the same.
It's okay.
We'll we're kind of lunch and learn from your desk. It's going to be 11 a.m. to 1 p.m. on Thursday, March the 11th, a week from today. And then on Thursday, March 18th, at 1 o'clock to 2 o'clock, we have a 1 hour presentation on covenant enforcement for community associations taught by Andrew Black out of the Pompano Beach office. There's one CE for managers. And then on Wednesday, March the 24th, from noon to 2 p.m., HOA board member certification. Andrew Black will be teaching again. This has got 2 continuing education credits for managers. Then on Tuesday, March the 30th at 4:30 to 7:30 p.m., that's a little long, is Community Association Board Member Certification by Emily Gannon. Will be teaching that one. I think that one. And then on Wednesday, March 31st, the very next day, is from 5:30 to 7:30, Condominium Board Member Certification. That would be taught by Allison Hertz. So that's what we've got upcoming in the month of March.
Well, I want to. We get everybody, try to get everybody to write in their questions, and since we're talking about certification, James in Deerfield want to know regarding HOA board members. Does the board members have to recertify ever?
Well, the statutes provide on certification, and that's these certification courses that we're offering, that if the board member is in continuous service on the board, the certification will last for 5 years. The method of becoming certified is to sign a form document that the the Department of Business and Professional Regulation puts out, or attend a proper certified course, which is what we provide. We believe that the course provides more information and assists board members in doing their function as board members, so it's the better choice. And as I say, it's good for up to 5 years of continuous service. If there's a break in service, say somebody takes a break for a year or even a day, then they'd have to do the certification over again.
Robert, in your firm, do you have to keep up with CDC guidelines? Are there certain guidelines for condos or associations?
What do you mean by guidelines?
Well, the reason why, like here, we have one of the people wrote in, asked, he said, has the pool rules with the CDC changed?
Well, the CDC isn't the guiding source of information specifically. I mean, they do put out information and recommendations, but it's the county level that's going to be addressing pool restrictions that any of us have to be concerned with. And at the current time, there hasn't been any significant changes in several months. So whatever's been in place remains in place, wherever they may be.
Okay. Let's go to Barb in Boca. They're changing their board, and the minutes from the previous meeting were not signed. How do we sign the minutes for the previous board, and are those contracts valid?
Well, if minutes aren't signed, that's not really something that's going to affect the validity of the actions taken by the board. If the new board desires, they could ratify the minutes or adopt the minutes as part of their standard business that they do when they start in their new term. An actual signature on it is not a critical requirement, and often minutes are not signed at all, but typically a board will start their next meeting by reviewing minutes of the last meeting and adopting them, or waiving the reading and just adopting them as appropriate. It's helpful if the board has personal knowledge about what took place, so that when they do adopt those minutes into the official records of the association, they know that they are correct and accurate. The contracts should remain enforceable.
Okay. I want to get us back. We got a late start on our last commercial. We're going to go to a commercial again. We're here with Kay Bender-Rimbaum. They are Community Association attorneys. If you have a phone call for Robert, you can call us at 888-565-1470, 888-565-1470. I know we get a lot of emails, people saying they think they're going to miss something if they call in. But actually, the show plays on the phone when they're on hold. Isn't that right, Freddie? Yeah, so you're not going to miss anything. So give us a call here at 888-565-1470. Robert just gave you everything that's going on in March. Give everybody the phone number and the website, Robert.
My phone number is 800-974-0680, and the website is kbrlegal.com.
Okay, we're going to go to our break. When we come back, we'll have more with Robert Kay. We'll be right back.
Kay Bender-Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kay Bender-Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kay Bender-Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kay Bender-Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
We are back. We're here with senior partner Robert Kay. He is the senior partner at Kay Bender-Rimbaum. They cover all of South Florida, Tampa. If you are a board member or a management company and you really want a great law firm that basically this is all they do, I would say 90%. It's not some attorney that's got 5 other shingles hanging up. And what's so great about them, they are really into customer service. We're back here with Robert Kay. Right now, if you've got a question, we do have one line open at 888-565-1470. I want to try to get as many questions as I can in tonight because I didn't last month because of all the phone calls. So I'm going to go to Ann in Boca. I guess she's part of a condo association. Statute 718. She wants to know what takes precedence in condo law, bylaws or statutes.
Well, it's not a simple yes or no, this one, that one answer. For the most part, the statute comes first, then the declaration of condominium, the articles of incorporation, and the bylaws. That's the hierarchy of order. But there are certain things that we look to the documents for, and there are certain things that we look to the statute for. And so it really depends on the item that we're talking about as to which one is going to be the guiding and the end-all deciding factor for whatever issue that may be. So I need a little more specificity from the inquiry that will tell me what items they're thinking in terms of, so that we could be more specific. So generally speaking, statute, declaration, articles, bylaws, rules.
Okay. It's really amazing. We've been doing this show for about 4 years now, and God, it used to be so many questions about pets, and now we rarely get questions about pets. It's either now about COVID or elections. It's funny how it's changed. What's that?
Whatever's hot for the moment. Right?
Yes. Okay, so let's go to Bruce in Palm Beach. He says, we have a new president, but the old president is refusing to give the password to get into the accounting files of our records. We just found out he has commingled the board in his own personal account. I would say he's in a little bit of hot water.
That would be an understatement. The unit owners there, or the new board there, can do a couple of things. One, they can get in touch with their attorney, and the attorney should communicate with the president to free up the records. Alternatively, they can contact the Division of Condominiums into their enforcement department to look into the issue of the financial irregularities and the lack of turning over of the information in a timely fashion. It may be necessary to bring legal action against this individual to compel him to give the association what is in their entitlement if he fails to do so on a voluntary basis. And that could be a big mess.
Yeah, it sounds like it. Let's go to David in Boynton. He's actually written us for the last 3 months, so I wanted to make sure I got him on. He said their HOA secretary told the members of our community their signature must be on our ballots. Is that true?
That is not true, unless their documents specifically require it. If the ballots are in person, the people that are signed in get a ballot, and they cast their ballot, and there is no indication of whose ballot it is, but your control is you give a ballot out as somebody signs in as being present. You give a ballot to the people with their proxies, but there's no requirement that the ballot be signed. If, on the other hand, they're doing it in an absentee mail-in version, then typically there should be a procedure where there's an envelope on the outside with a signature, an envelope containing the ballot on the inside that maintains the secrecy of the vote. Unless the documents themselves in the bylaws or articles require that a ballot be signed in order for it to be valid, there is no legal requirement for that to be the case.
Okay.
By the way, I see my banner at the bottom, and our firm name is spelled wrong in the website, so our website name. It says BBR, but it should be KBR.
Oh, I see that. Let's go to Jim on the phone. Hi, Jim.
How are you?
Good. Do you have a question for Robert?
Yeah, our co-op has a rule that you can't have any animals other than service animals. And it started out as one animal that was a comfort animal, and now there are about 5 animals in here that have these $39 coats and certificates, and a couple of these dogs are barking all night long. And I just wondered, what's the state's position on comfort animals other than the legitimate service animals?
Well, there's 2 types of animals that are at issue here. There's what you're calling the service animals, which are basically dogs that provide a specific service to somebody who has a disability. And then there's the emotional support animal that can be something more than just a dog. And there are certain medical requirements or documentation requirements that are fairly minimal in order to qualify. But once you have the qualification in place and they are quote unquote legitimate service animals or emotional support animals, that doesn't mean they have carte blanche to be a nuisance. The board should have in place rules and regulations that deal with how emotional support animals or service animals are to be handled within the community, which could include limitation on nuisance type behavior. As we've seen many times through the years, it's not the animals that are a problem, it's the owners. And if an owner's not going to take care of an animal that's making excessive noise, barking at all hours of the day and night, that owner's entitlement to have the animal is not absolute. So the association could require the removal of a nuisance animal if they don't live within the rules. The first thing you need to have in place is a set of rules that cover this issue for you.
Well, the set of rules say that you can have service animals, and then all of a sudden we end up with all these emotional support animals. And I thought the state came out with some guidelines that said that emotional support animals were not considered service animals, and that you didn't have to put up with them.
Well, service animals is really a term that applies under the Americans with Disabilities Act, the ADA, and that's for places of public accommodation. There's a spillover into housing, but the fair housing FHA laws deal with more of the emotional support animals. And there is a bit of an overlap, but service animals are required to be trained and have certification. And your inquiry that you can make is very limited as to the qualifications. The emotional support animals needs a qualified medical provider to identify a major life function that is impaired and that this specific animal will allow the owner full use and enjoyment of the property. Again, allowing them in is step one. Once they're there, you need a set of rules and regulations to deal with their behavior in the community, and that's what sounds like you're missing.
Okay, thank you. Appreciate that.
Thanks, Jim.
All righty, thanks for listening.
Jake and Pompano said the COVID virus has postponed their elections. What do they do?
Well, Jake, you still need to have your elections, and we have many of our clients who are doing them electronically. We're using like a Zoom platform, and the owners are able to attend and participate. There will be a on-site location for collecting of the ballots and proxies and information like that, but no gathering of a large number of people. And they're able to accomplish their meetings in that fashion. It's allowable under the law, and it's something that should be undertaken.
If you'd like to call in, we have a line open now at 888-565-1470. We're here with Robert K. from K. Bender Rimbaum. It's a community association firm here in South Florida, also in Tampa with their new office. Bruce from Palm Beach says we have a new president, but the old well, no, that's the same one. I apologize. Yeah. Penny and Boca had our annual meeting, and I resigned as president. The guy that wants to take my position is 3 months late on his maintenance dues. Do we have to let him on the board?
Well, the answer to that is not only do you not have to let him on the board, but you cannot let him on the board because he does not qualify to be on the board by being over 90 days in arrears on a monetary obligation to the association. So even if he was already on the board, once he crosses that 90 days, he's automatically off.
Oh, okay. So even if he was already on and you get 90 days past due, they can kick you off the board.
And it's important to also bear in mind that it doesn't necessarily mean that some people will pay a portion of it, so it's not 3 full months behind, but it goes back to the beginning of the delinquency. So if somebody is 2 months behind and then pays a month and then goes 2 months behind again, they're actually over 90 days when the arrearage began.
Gotcha.
And you can't really get away with that game. You have to totally zero out your account in order to no longer be considered as disqualified.
Jay and Davy, he is on a condo. What if management can't get a condo owner, and we've talked about this before, to take a political sign down? It's been up there for 8 months, and we can't get him to remove it.
Well, assuming that they have a prohibition on signs within their condominium, they would then pursue enforcement as any other violation, which would be file a petition for arbitration with the Division of Condominium and then litigate the case either through the arbitration or into the courts to compel that owner to abide by the rules and remove the sign.
We are going to go. Oh, who do we have? Oh, let's go, before we go to break, let's go to Patty at Deerfield Beach. Hi, Patty.
Hi. I just have a quick
Hello,
question.
Patty.
I've been looking at our documents and our bylaws, but I was just wondering if you have a like say a roof project and we've assessed the members $3,000 each and it's a pooled reserve and the project goes, I don't know, I just want to say it goes $10,000 over budget of what we assessed everybody. Can the board just vote to take the rest of the money out of the reserves, or do we have to reassess the members, whatever the overage is? Or is that
So
just
I'm
something
clear.
that should be in our
You have a
document?
pooled reserve and your project is going to go beyond the amount that you have allocated for that particular item in the pool?
Right.
Okay, well, the purpose of the pool reserve is so you have the funds available to you when you need them, but that doesn't mean you can use what's designated for one mandatory item for another. So you will have to replenish your pooled reserves as to the amount that went over what was designated for that item.
So we have to do another assessment?
Yes.
Okay. So in other
Either
words...
that or a vote of the owners to waive it or reallocate it.
They would what?
You could also have a vote of the unit owners to reallocate that portion from whatever it was designated
Okay,
to the
right,
roof.
okay. All right. Rather than have another assessment.
Correct. But then your reserves are going to be short.
Right, which, okay. Thank you so much.
Thanks, Patty.
Great night.
Thanks
Okay.
for listening.
We have another line open at 888-565-1470. Let's go to Bill from Green Acres. Hi, Bill.
Hello. I have a small problem, which I hope you might be able to give me some advice on.
Robert can fix
we
you
have a
up.
landscaper. I live in a homeowners association, and the board has hired a landscaper to do all the landscaping around. These are all private homes, and the landscaper is just he's more a vandal than a landscaper. And I'm just tired of arguing with this guy and repairing all the damage that he does. Now, the board says, well, you can opt out. But what they mean by opt out is tell this guy not to come to my house anymore. But I'm still, in my dues, I'm still paying this guy. So the more people he gets to tell him not to come, the more he gets paid to do nothing. So is there any hope that if I tell this landscaper I do not wish to receive any services from him, I can expect or hope to get any kind of refund from my dues that would be going to him.
Unfortunately, if your documents provide for the association to be responsible for the landscaping, then you're going to have to pay whether you use those services or not. So
Well, I don't believe it's in the documents. I've looked at the documents. I mean, the board just took this on themselves. And I mean, everybody wants this, but what everybody doesn't want is a landscaper that's incompetent and does more harm than good.
Well, if there are other owners that share your opinion, it might help to put yourselves together and petition the board to make a change. It's possible there may be something else going on between the board and this landscaper that might make that more difficult, but it's hard to guess. If your documents do not entitle the association to use association funds for that purpose, then you wouldn't have to contribute to that if you opted out. Then it becomes a voluntary situation. Before you do any of that, it would be a good idea to have an attorney reviewing your documents and make sure that there's nothing in there that might put you at risk, because you don't want to find yourself in a collection situation for unpaid assessments with a lien and additional attorney's fees and costs on top of it.
Right. All right, you've been very helpful. So, in other words, now I happen to live where I am. I'm in Riverbridge, which is a property owners association, which is the master association, and then underneath that, the sub-association is the homeowners association. So I would have to go through both sets of documents to determine whether or not there's, I guess you're saying that it has to be in the documents that the landscaper is provided for? Because what
Yes.
they do is...
Which association is doing it?
Well, it would be Hammocks Trail, the sub-association.
So the sub-association documents would be where you'd start. If they're the ones that are doing it and including it in your assessment, then that's the documents that are important as to this issue. You wouldn't necessarily have to go through the master documents unless there was a delegation from the master to the sub.
I consult the proper documents, because they claim that the property owners association documents trump the homeowners association documents. So,
Well, they do different things.
okay, well, I will start first with the homeowners association, and if I find that there is no mention in the homeowners association documents as to landscaping costs, because what they do is they simply put it into the maintenance, dues or whatever you want to call it,
Sure.
and you have to pay them quarterly, and then this landscaper is paid, by the homeowners association.
Okay, but even so, you may want to consult with an attorney on that who's versed in the
Oh, I
area.
definitely will. Well, that's the whole reason I called you, to just get to point me in the right direction. You've been very helpful. Thank you very much. At least there's hope that there might be some way out of this, because this is, as far as the board is concerned, of course the landscaper takes superb care of their property. Why wouldn't he? Okay. Well, listen, I've taken a good deal of your time, and you've been very helpful. Thank you very much.
Thank you for listening.
And if you need a good attorney, K. Bender Rimbaum, give them a call. We have another line open, 888-565-1470. 888-565-1470. I got to get to these people who wrote in, took the time to write in. Merrill from Boca wants to know, how does an out-of-towner get to vote when they say they never got their voting package?
Well, that's a problem, and I assume we're talking about a condominium, although I don't think it indicates that.
No.
In condominiums, you send out a first notice, a second notice with the ballots in it, and the owners have to fill it out and send it back, as we've discussed before. So in this instance, if the people from out of state or in other cities haven't received it, it's incumbent upon them to be in touch with the association to let them know and make other arrangements. Copies can be sent via email. They can use express mail service like a FedEx to get it back in time. I assume they're not using electronic voting yet, so that isn't an option for them to consider. But the out-of-town folks are going to have to be a little bit more assertive in protecting their own interests and make sure that if they haven't received it by a time that they think they should, that they are proactive with reaching out to the association to get other methods going.
Okay. Let's go to Dominic in Hollywood. Hi, Dominic.
To know if in a condominium, if a non-owner wants to participate on the board, are they allowed in the capacity of being an assistant to the president and also to the treasurer?
Well, the first thing to do is check your articles of incorporation to see if there's a requirement that people serving on the board be owners within the community. Because the statute provides, unless the articles indicate that requirement, then they are not required to be owners. Assuming that they are required to be owners, the board can appoint to committees or other types of positions individuals who aren't owners to assist them. They don't have a voting power on the board, so there wouldn't be any legal prohibition for that unless your documents expressly state that, which would be unusual.
Thank you very much.
Thank you.
Right, Dominic.
How about Charlie in Plantation?
Guys, thank you so much for doing this. Great show, by the way, very helpful.
Thank you.
Robert, you mentioned about people owing money and not being able to run for the board, and you gave an indication earlier of 90 days. Can you explain a little bit more? We were under the impression that it's 90 days in a condo and $1,000. Are you saying that if at one point they were over 1,000 and they qualified to be suspended rights for voting or being on the board or something like that, that they can't be if they fall back? Can you explain that little part again, and where does the $1,000 figure into it?
Okay. The qualification to serve on the board issue is separate from the suspension of voting rights or other types of suspensions for monetary obligations. And they're in different parts of the statute. In section 718.112, subsection 2, subsection N, it provides that any individual who's more than 90 days in arrears is not qualified to serve on the board. So it does not specify a dollar figure. In 718.303, where it puts in for the suspension of use and voting rights, that's where you'll find the $1,000. Now, the qualification for service on the board, once somebody becomes delinquent, that's the starting point of the clock. It doesn't mean that they owe 3 months worth of assessments, but they've owed some monetary obligation continuously for more than 90 days.
Okay, I got it. I see the difference. Thank you very much for clarifying.
My pleasure.
Thank
you for listening.
Wow, busy night with the phones, too. We only have a few minutes, and I want to get out the information, phone numbers and everything. I apologize to the 3 people who are on hold. But please call us back next month. You're on the first Thursday of every month from 6 to 7. Give everybody the phone number, first of all.
800-974-0680. You can write to us at info@kbrlegal.com. or go to the website, kbrlegal.com, and you can find all sorts of information there.
Yeah, there's really some good reading on there, especially if you're a management company or if you're on the board. Wow, it's been a busy night.
We've got Ask the Attorneys next Thursday at 11 o'clock.
Next Thursday. As usual, great job, Robert. Wonderful job. K. Bender Rimbaum, they're with us the first Thursday of every month. And, hey, I like your new commercial, too.
Oh, thank you.
Okay, so we'll see you again. Have a wonderful weekend, Mr. Robert, and thank you. People I know love the information you give them.
It's great to be here. Have a good month.
Bye-bye. And we'll see you guys Monday from 6 to 7.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.